versus EPO. Who gets to rule first on the validity of a patent? But joining me today are two highly experienced UPC representatives and also good friends of the show, Florian Meyer and Julian Würmser. Gentlemen, great to have you with us.
Thank you, George. Thanks for having us.
It's a pleasure to have you. Florian, thanks for being on the show. And this is the first time I think we've had anybody from the show from Hamburg, so I'm interested.
Well, I'm sitting in Munich, though.
That's true.
I am from Hamburg.
That's true. Okay, so let's get to it, guys. I know we covered this before, but having two shots at the validity of the same patent in parallel appears rather awkward. Is this indeed legal, gentlemen? Julian, what do you think?
Well, George, first of all, what you have to recognize is the proceedings are not totally identical. In essence, like the outcome, potential revocation of a patent is the same, but there's some difference to this. And so the one at the EPO, the oppositions, that's a proceedings that's only available within 9 months after grant. And it gets decided by an office rather than a court, so that's the opposition division. And it's something that we call it Popularrechtsbehelf, nice bit. So it's basically the idea here is to serve the public an opportunity to kind of do something against a patent that has been granted and shouldn't be there. On the other side, we have the second train running here. So we have this counterclaim for revocation. That's what's happening at the UPC. And here, this is really a classical court proceedings with everything attached thereto, very strict rules. And contrary to what we have on our nullity actions here in Germany, the UPC does not have this bifurcated system. So the counterclaim for revocation tends to be an integral part of an infringement action. So first of all, we have to establish these two trains. They are a little bit different, as said, same outcome. And now coming back to your question about legality, whether this is really, really legal, it should be the exceptional situation that you have these proceedings running in parallel. Nevertheless, it turns out that they appear to be rather common in the cases that we have seen so far. And there are basically three scenarios that could happen. A potential infringer is aware of a patent and he opposes to that. And then the patentee, the holder of the patent, decides, I'm going to start my UPC action against that guy anyway. This is how the two trains get started in parallel. Another scenario that's thinkable is an infringer gets sued at a very, very early stage, namely within said 9 months. And he kind of checks, what can I do? Of course, I'm going to do my counterclaim for revocation, but why not? Let's also file the opposition at the European Patent Office. So that's the second scenario. And the third scenario is, let's assume the patent has been opposed at the EPO by any third party. And then suddenly I, for example, get sued at the UPC. And then I check, what can I do? Counterclaim for revocation at the UPC, of course. But then I also see, there's this opposition running. Why not join this opposition? And here the EPC basically provides a means that you, as another party to the opposition proceedings, can join the opposition. And so these are kind of the three scenarios that could happen. And to answer your question, yes, it's perfectly legal to have that. But in theory, it should be more the exceptional situation that this happens, which doesn't really quite relate to the reality.
So it's the exception more than the rule. But okay, but why was the system designed like that? Florian?
Yeah, it sounds a bit complicated, and of course there were alternatives. However, probably very early in the process, the decision was made that, unlike the German system, which is a bifurcated system where we have the validity of the patent checked independent of the infringement, there was a decision made that this should be dealt with within one proceeding. So the infringement courts are responsible not only for determining infringement, but also for determining the validity of the patent. And so if you want to have that, that means that, of course, once there is an infringement action, you have to allow basically a counterclaim for revocation within that same process. Still, And in addition to that, basically, of course, there was already an established system. So the EPO opposition proceedings, they're well established, there are rules, there is the EPC that are well in place already. And so they didn't want to change that, I suppose, because of course, maybe you would have to change some rules there as well if you want to have the systems intertwined a bit more. But now they're really separate. And as Julian mentioned, they also have basically cover different territories. The opposition covers the entirety of the EPC, while the UPC only covers 18 states right now. And so the system was basically designed like that so that the UPC can exist independent of the EPO, I would say. And I think one of the main reasons is also that the UPC will never be dependent upon the speed of the EPO. Of course, speed is one of the very important pillars on which the UPC is based. And the infringement proceedings are supposed to be concluded within 12 to 15 months, maybe. And of course, you want to ensure that, and then you need to be in control, basically. In addition, it creates a bit of a competition between these two systems, and it kind of like encourages the EPO not to be slower. And they also put some measures in place for this, but I think we will talk about this a little later.
Yeah, that's pretty interesting. So I get it. So we have two trains running in parallel, one at the EPO and one at the UPC, both destined to potentially invalidate an EP patent. So can you at least confirm that the rules applied are the same, or are they not? Julian? Or
Well,
Florian?
you know, we attorneys, we give the rule a particular meaning. And if you consider this narrow meaning, the answer to your question would be quite simple. But let's look at this question on multiple levels. And let's start with the easy ones. So just for the ground for revocation, the ground for invalidation of the patents. Okay. So here the game is almost identical. We have added matter, workability, novelty, inventiveness. And these are kind of the most important ones. And here the UPC refers back to the EPC. And so here we have legally an identical situation. Okay. Already when we come to admissibility of claim amendments, so the natural first step or an early step that you would take in such revocation actions is that you want to establish fallback positions. That's why you're going to file auxiliary requests. And for these auxiliary requests, it's always for us patent attorneys, it's always an important question, are they admissible or not? And when looking at this admissibility, also we have more or less identical scenarios or very similar scenarios, at least on paper when you look at the rules. So we have clarity, proper support, that's pretty similar. And then we have another ground, kind of a hidden champion for me. It's Rule 80 EPC. It's the idea that when you file amended claims, that you cannot just use these claims to fix something that you just found out that you were not aware. So when you file these auxiliary requests, they need to be targeted towards responding to one of the revocation reasons. And here there was also already at the UPC, there were kind of a little bit of a discussion. Does this Rule 80, does it apply or does it not apply? Current case law, I think it's Fujifilm versus Kodak, would point in the direction that they will not apply. So here we already have more or less on the rule level, different rules, and maybe a little bit a different design of the two trains running in parallel.
Gotcha. Now, Florian, what do you think about it?
Yeah, so the procedural aspects are one thing, but of course, what is important for the validity of the patent are also the substantive questions, novelty, inventive step. And here, Julian mentioned, the legal basis is exactly the same. So it's the Article 56 for inventive step, for example. And the UPC agreement also actually refers to the EPC in this regard, so that the UPC-A, the UPC agreement, actually doesn't contain any provisions on these matters. So it is really a reference to the EPC. However, and that's most important, the UPC is not bound by the case law of the EPO. And so the question is, how do we interpret these articles that are formulated in the EPC? And it's really about this interpretation. How do we assess inventive step? Because if something is non-obvious, of course, we need to fill that expression with some meaning, with some life. And so in the initial decisions that we've seen from the UPC, we've seen some distinguishing elements from the EPO approach. The EPO approach traditionally and for many years, and it's well established and it works at the EPO opposition proceedings in particular, is the problem solution approach. You identify a closest prior document, you determine differences over the claimed subject matter, define the objective technical problem that is solved by the claim, and then you determine whether the solution to this problem is non-obvious in light of maybe further prior documents.
Okay.
And so there is one of the key aspects of this approach is that you identify a single piece of prior art in the beginning as your starting point to determine the question of whether the invention is inventive or the alleged invention is inventive or not. In the German system, we have had a somewhat more, let's say, flexible approach. In the German system, it was always a bit different, and that not a single document was considered, but it's more about what is a realistic starting point, where does the person skilled in the art start from, and that can be a more generic knowledge. It's not a single piece of prior art maybe, but maybe more knowledge about a particular field and a particular problem. And the UPC seems to have adapted in the initial decisions that we've seen a bit more the German approach, explicitly stating that problem solution approach might have the problem that it's favoring a more retrospective evaluation of the inventive step question and not looking at from a very subjective and not objective, which it's supposed to be. And so there were some decisions that really said, well, we are not going to do problem solution approach. And then now in April of this year, we have seen a new decision coming from the local division of Munich, which takes a different direction, basically stating the problem solution is a possibility to determine inventive step. It doesn't say it has to be the problem solution approach that the EPO is using, but it's a viable and it's actually the preferred way to do it because you want to harmonize the approach of the EPO and the UPC. So at least the local division Munich seems to accept this approach, and now we will have to see what the second instance will do with this decision. But really important also from the decision in Munich, basically they emphasize that the starting point is important, and that's why I say the single piece of prior art document in the problem solution approach and also in a German approach or then maybe UPC approach, it's really important to determine what's the starting point to determine this question of inventive step. And so what we can see is essentially, even though the provisions are exactly the same, obviously it's the identical wording, there can be different interpretation of the law. And so we have to see whether they are going to harmonize it even more or whether the Court of Appeal will say, no, problem solution approach is not the right way to go. We have to wait and see where this leads us. In any case, there are also more important procedural aspects that are really important when looking at the cases. And the similarity is that both proceedings, the opposition proceedings and the validity proceedings at the UPC are very much front-loaded. Okay. That means that you have to provide all the evidence, all the prior art, and also as the patentee, all your auxiliary requests as soon as possible. And it's very difficult to introduce new arguments or new prior art and new evidence at the later stage. You will have to provide good reasons why it was not possible, essentially, to do it earlier. And this is really a common theme, both at the UPC and also at the EPO. It's really front-loaded, and that's a big distinguishing element compared to, for example, national proceedings, where it was always much easier to introduce, for example, additional auxiliary requests at a later stage. Mm-hmm. At the UPC, of course, if you want to keep this time frame, you have to be strict on allowing additional evidence to be introduced because, of course, it needs to be discussed. You want to write about it. And so they have to kind of like block the admissibility of additional evidence at a later stage.
Now, it sounds pretty tricky. I mean, trying to find the right line between EPO and UPC. But okay, that's all very interesting. But let's get back to our topic. We know that the UPC has proven to be an incredible, fast, and solid court system. So the judges are working very hard to arrive at an advertised time frame of 12 months for the infringement case, including the count claim revocation. Is there a realistic chance that the EPO will ever get to announce a decision on the validity prior to the UPC? Now, that's an interesting question.
Yeah, of course. And let's say the EPO accepted the challenge. Of course, it depends a bit on the time frame. As Julian mentioned initially, so the opposition period is 9 months, right?
Right.
And so usually the opposition proceedings really start at the end of the 9 months. Then the patentee is informed there's an opposition, he will file observations, then there might be another submission or 1 or 2 submissions by the opposing party. At some point, the EPO will provide a preliminary opinion and a summons to oral proceedings, and then you will have the hearing. With the start of the UPC, the EPO announced a measure to ensure basically that the UPC is not going to be a lot faster by allowing accelerated opposition proceedings in case there is a parallel UPC infringement action pending. And this accelerated proceedings, you have to request it, of course. You have to provide a docket number of the UPC action and prove there is actually an infringement action pending. This will very much accelerate the proceedings. And what we've seen now in our cases, that means that you will have a hearing in less than, or roughly less than 12 months maybe, after the opposition is started. And so it is incredibly fast to get to this decision. And then, of course, the question is, what will happen? Will the UPC hearing be close to the hearing at the EPO, or will there be something else? So this is a question that the timing becomes really important. What happens when? And that's very interesting, actually.
I can butt in here for a second. So what Florian just described is the first instance. So we almost at the EPO, we don't have it physically, but we almost have a guarantee that we're going to get a first instance decisions at the EPO within 12 months. With the appeal, and with the appeal, it's open. The boards of appeal said they're going to do their best to kind of make a quick decision. But what that really means, that's totally open, because like recently we have seen rather long appeal proceedings at the EPO. They're very crowded. They have quite a lot of cases. So we don't really know what it means on the second instance. So that's open.
No, come on now. But is it really realistic that the UPC will stop its incredible fast-moving proceedings to wait for the outcome of opposition proceedings? I don't know about that.
Well, the legal means that we are talking about here is the stay, and maybe we first quickly look at the law. So that's our Article 33, Section 10 of the UPC agreement. And there it basically says that the court may stay its proceedings if a rapid decision may be expected from the EPO. So that's the legal basis for that. And when the UPC started, they really, as said, they did everything to work fast on their cases. And generally, what we have seen in the last months is they established a no-stay culture. They're working hard to get these cases moving forward, and they want to meet their 12 months time frame. And so they tend not to stay. There was at least what we have seen at the very beginning. Now, with a couple of cases, we see that there is sort of a consideration of staying, or maybe of arranging, scheduling the proceedings in such a smart way that they can take in either the preliminary opinion from the EPO or maybe already the final decision. So from our perspective, this very strict no-stay culture is loosening a little bit up. But for them, it's still very crucial to get their cases moving.
So then, with the speed and everything, to sum it up from a plaintiff's view, is it smart to expose yourself to both proceedings, opposition and counterclaim for revocation? What do you guys think?
Usually, of course, the answer would be no, you don't want to do it. But of course, it depends on the situation. As always in law, you have to look at what is your scenario that you're dealing with. And of course, there are scenarios where you simply cannot wait, where you want to initiate your infringement action really quick because maybe a competitor is going to bring a copy product to market. So you're looking to get an injunction really quickly, and you want to basically get the proceedings started. maybe you start with preliminary injunction proceedings, but then that also forces you to initiate proceedings really quickly. So there are situations where you simply cannot wait. Or it might also be the scenario where your patent might expire at some point and you just want to start as early as possible. In addition, it might be that you just want to increase pressure a bit more. So basically, you increase complexity of the case by allowing essentially two proceedings run in parallel, and that depending on the pockets of the parties involved, it can be in your favor.
But quick question: is there a risk, or Florian, is there a risk when both things are running parallel to get what you want out of them, or?
As a plaintiff, as I mentioned initially, as a plaintiff generally, you would not want to have two proceedings that attack your patent in parallel, because of course it's two shots. As Julian mentioned, the EPO opposition proceedings, they can invalidate the patent in the entirety of the EPC countries, so that's a total of maximum 39 countries versus the 18 of the UPC. And so if you don't have to, my suggestion is wait another month or so, depending on how long the opposition period is running, to minimize the risk for your patent asset and in that case.
And maybe looking at the topic from the potential infringer's perspective, very few, very particular scenarios where as a patentee, having these two proceedings in parallel might actually have some merits for you. But when you look at this from the potential infringer's perspective, it's pretty safe to say it's a good thing to have it. So when my perspective, I would always recommend also file the opposition, because what we are seeing, the standards on the more formal aspects at the EPO currently, they appear to be significantly higher. So there are more formalistic problems that the patentee is going to face at the EPO, which kind of makes a successful invalidation more likely at the EPO.
Wow. Okay. I mean, it's kind of like a developing trend. Would you say that, Julian, or?
Well, as we said at the beginning, I mean, this option of having an opposition in parallel, you tend not to always have this. But what I'm kind of saying is, like, if you have it, take the opportunity. Currently, we are seeing a lot of advantages when you try to attack a patent, and if you do it in front of the EPO as well.
Okay. Well, guys, I'd like to thank you. That was pretty interesting. And I'd like to ask you guys to come back on the show if you guys ever have time again. But that's going to wrap it up for this edition of the UPC.Insights. Thanks to once again, our wonderful experts, Florian Meyer, thank you for joining us today. And Julian Würmser, as always, thank you. You guys always bring a lot of insight and information to the table, and I appreciate that, especially for our listeners. Thank you once again. And of course, we'll be bringing you more distinguished UPC representatives and guests in the near future. All of us at the UPC.Insights are really happy that our listeners took the time out from their busy schedules to tune in with us today. And we have a lot of great UPC.Insight content from past shows that are more relevant and exciting than ever, and we urge you to check them out on our YouTube channel or our website at meissenbolta.de or at meissenbolta.com. Ladies and gentlemen, I wish you a nice evening. Julian, Florian, thank you once again. It's been a pleasure.
Thank you, George. It was fun.